New Texas Family Law Updates. An update with attorney Dannielle Simms of Simms Law Group. That is our conversation for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac Pearley. Welcome back to Lawyers Mediators International. And it's a show where we talk about law and conflict resolution topics to educate both professionals and everyday people. So welcome back, everybody. We're going to be talking to Dannielle Simms today. How are you doing, Dannielle?
I'm doing well. How are you?
Good. Well, thank you for coming back. And it's been a little minute, but as we know, you come here to educate on Texas family law because you are a Texas attorney. But before we get started on today's topic about legislative updates and the law changes, why don't you talk a little bit about yourself to just introduce yourself to the public?
Well, it's good to be back. Thank you for having me back. Obviously, you guys know I practice in Texas. If you can't tell that from Mac's introduction, you can definitely tell it by my hair. It is summertime, guys. So luckily I'm not in Florida where it's not even more humid. I'm based out of Houston, but I practice in Fort Bend County. I practice in Brazoria County. I practice obviously in Harris County, Montgomery County, Texas counties, you name it. For the most part, I'll travel to it. I've been licensed and practicing for about 13 years. I'm not, after 10, it gets blurry. I practice primarily family law, CPS litigation, and some estate planning. And I'm just here because we've got some updates that I found interesting coming in for September of 2025.
Yes. So let's talk first about why we're doing this. Okay. Look, the law changes, as everyone knows, but in family law, whenever the law changes, it's a pretty big deal amongst attorneys because we want to make sure that we're protecting our clients and we want to make sure that people know what exactly it is that they might be held accountable to. So can you just give us some thoughts, broadly speaking, about law changes and why this is so important?
Well, to start kind of going backwards, why is it so important? We practice family law, and not that other areas of the law are not important. All areas of the law are important. Obviously, we're attorneys, so everything involving the law is important to us, no matter how small it is. But family law is particularly important because it impacts the day-to-day lives of individuals. There is not one space that you will go to where you can't throw a rock and know somebody that has been in a family law situation, whether it's as small as getting rid of that Vegas wedding they had for 24 hours or actually having some major custody dispute or even termination of parental rights. Family law touches everybody's lives. Family law can touch your life from the time you are an infant and unaware of what's going on to the time you're a full-blown adult and making decisions. So that's why I believe that when you're hearing about changes in the law and we are learning that things are going to potentially impact our clients, it's not just about the impact of our clients, it's about the impact of the general public, all the way to professionals, because let's call it what it is. You see divorces from folks that are even attorneys, and it impacts everybody's daily life. And so that's why it's important to get these legislative updates out there. But on that note, people need to be educated on the legislature. They need to be educated on local politics. Obviously, I'm always going to push for that. Be aware of who you're electing. Also be aware of how that election can impact you day to day, no matter how small it is. But also know who is influencing the law changes. Like, for example, if you have lobbying groups, I'm sure that everyone that's watching this is smart enough to know what a lobbyist is. But in the event that you've never really heard that term, who's out there truly advocating for issues that end up before the legislature and that ultimately become law? We all know from just movies, you hear about big tobacco and then oil and things like that. Guys, for every big tobacco lobbyist group, there's also lobbyist groups for family law, right? Yeah. There's groups that go out there, and I wouldn't even call them lobbyist groups necessarily, but they kind of are. But there's groups that are out there for things like father's rights, right? You hear a lot about that. There's a groundswell in that. There's also groups that involve just family lawyers and professionals that are in family law that kind of understand the nuances and how they impact their clients. And they lobby for things like making courtrooms better for their clients, better impacting laws for their clients, also making sure that judges can't go too rogue when they're making decisions, right? Because they're supposed to be within the confines of the law. And so it's things like that that people need to be aware of, and you need to always be keeping in mind who is representing you, because you might go into a situation and be advocating for people who wear ties. Well, I don't wear ties, right? And so what if Matt goes to the lobbyist and all of us, or excuse me, to the legislature, and all of a sudden it becomes mandatory to wear ties? Well, that directly impacts me, right? And anybody that's like me that doesn't wear ties. So it's things like that I think it's very important for individuals to know what's going on. And that's why it's so important to me to give this update, because we find out a lot of times about these updates in hindsight, right?
Correct.
After they've happened. Like, for example, you and I and most family law lawyers, in August every year, we go to a CLE, or a continuing legal education seminar, called Advanced Family. It's about a week long, and that's where we learn, are there updates, or we learn how to litigate better, we learn how to mediate better, we learn how to settle cases better, we learn how to better service our clients, but we really learn about the updates. The problem is, sometimes when I go to those things, I learn about the update, but I don't really know how we got to that space. I don't know why that topic became a hot topic for the legislature, because it's not every time that they meet that they even impact us. A lot of times they impact us, but it's not every time that they meet that they impact us. And so being able to know how the sausage is made, or why it became important, that stuff is interesting to me.
Yeah, absolutely. I think you said a lot. I mean, one of the takeaways I got is just get involved, and so you can know the process. I can't tell you how many times when I used to work for the Attorney General's office, I would get calls from people who would basically complain on the phone and ask, well, that's not fair, or why is it all like that? And the typical response would always be, well, that's why you vote.
Right.
Right. And this is why you can have an impact in what happens in Austin, because they're literally cooking the sausage, as you say. They're making the law, and they're being influenced by other people. And
Right.
so you can be one of those people who influences as well, because you have positions, you have opinions, you're president of the state, so you can have a say in how this stuff actually comes out. And so with that, let's get into some of the new upcoming changes in the law. So what do you have for us, Danielle? What's the first one, would you say?
So there's been quite a few changes over the course of this last legislative session, but the ones that I found most interesting, we're going to go to, which is an impact on standing for non-parents and how they get into lawsuits. And we'll kind of talk about what that is. The next topic that I found interesting was what happens when a parent is denying possession and access to another, because that's a huge topic. It's a huge problem. And so what I think the legislature has done in that respect is tried to become way more proactive in handling that situation. And there have been some changes to CPS law, which I find very interesting, and I have several opinions on, but this is not my podcast, so I won't give too many opinions. But there have been some changes that I have found interesting over this last legislative session.
Yes, so let's jump into standing.
Okay.
First, we got to give people the definition of standing, or maybe not a specific legal definition, because we're not encyclopedias. However, well, sometimes you are. However, just a broad idea of what standing is and why it's important, because this is going to impact some people who think they can just walk into court and say, hey, here I am, I want rights.
Right.
It's not that simple now, right?
No.
So, go ahead.
So I don't consider myself an encyclopedia. Maybe more Ask Jeeves, and that just kind of ages me, but maybe more Ask Jeeves. So to the standing process, how did we get here? And I was going to sing that, how did we get here? And I've done it, and that was going to stay in my mind. But here's the deal.
We're being recorded.
That's fine. Here's the deal, guys. When you are seeking litigation against anybody, I don't care what area of law it's in, whether it's torts, whether it's family law, whether it is even criminal law, you have to have a basis on which you are filing a lawsuit and a right to file said lawsuit. And so standing really speaks to, what right do you have to file this lawsuit? Case in point, if you got a divorce and you as the wife, you are filing a divorce, what gave you standing to file that divorce? Well, you're the wife, right? And I'm saying these terms to you. Obviously, there's more legalese with it and there's more nuance, but you are the wife. So that's what gives you the ability to file a divorce. If, for example, Mac and I were married and some lady down the street just decided to file a divorce against Mac and she's never met this guy in her entire life, that would be a problem. So it's about the right to bring the type of suit that you have. So circling to one of the major topics that I see out there is what happens when you have a non-parent who wants to file a suit for custody. That often falls into foster parents. You'll see that fall into family members is what I see a lot. I don't know about you, but I see a lot of grandparents. I see a lot of aunts and uncles. And sometimes what you'll see is not necessarily blood relatives, but someone who has been around the child since inception. You'll see them try to file lawsuits. I know that, kind of historically for me, I've got people who I call Aunt so-and-so, and that person, if we took a genetic test, it's not related to me at all. They've just been around since before I was born. They've been around since I was in my mom's belly. So that's just how I know that person. And so when it comes to the standing statute, it's making sure that not every Tom, Dick, and Harry can just come in and file a lawsuit to take a child from a parent, because in Texas, you have a constitutional right to raise your children, obviously within reason. And when you go in and you want to usurp someone's constitutional right to raise their kids, you better have a basis on which to do it, number one. But number two, well, these are really equal. You better have a leg to stand on, i.e. have standing. So one of the things that I see come to my office a lot is you have grandparents who will come in and they want to file a lawsuit for their grandchild. And I have to ask them, number one, why, right? Mm-hmm. And number two, how do we get to a space where I can tell this judge, yes, this is a grandparent, yes, this is a parent, and they should override their parental rights, right? You see statutes, particularly under 102, you see statutes that talk about relatives, what consanguinity they have to fall within. You see that they have to plead significant impairment. You see things of that nature. Actually, let me back up a little bit. Historically, when you are filing a suit as a non-parent, you allege standing under the statutes that are under 102 and other areas of the family code. You allege that there's significant impairment. You do things of that nature. There's a lot of nuances to it. Well, now coming up, what you've got to do in addition to alleging standing is include an affidavit that specifically speaks to why you're entitled to standing. And that will be under 102.0031, which is a required affidavit for standing of a non-parent. This language was added under Bill 2052 and will go into effect September 1st as of 2025. And this is going to apply to suits that are pending in a trial on or after the effective date of this act. That's different because before, a lot of attorneys have the opinion that once you file a suit, it's up to the other side to get rid of you based on lack of standing, right? And a court can do that as well on its own motion, but generally it's you file and I've got to turn around and go, hey, this person doesn't have standing, and then we're in a fight of is there standing or not. Well, here, if you're not filing the affidavit, what it says under 102.0031 section B2 is that your relief shall be denied. It shall be dismissed. And unless the court determines that your affidavit actually contains the facts that are necessary. And guys, when I'm looking down, I just want y'all to know that I'm making sure that I'm referencing information correctly, because despite being this encyclopedia, I don't have everything committed to memory entirely. And so that affidavit makes a big difference.
Absolutely.
Okay.
And so this is a pretty big deal. Some people would say things like, there are no grandparents' rights in Texas, because a lot of people believe that the first hurdle we got to overcome is that standing requirement. It prevents a lot of people from being able to just go in and do what they want. But now there's an even more onerous, addition to it, where you have to prove, through a sworn statement affidavit, that you in fact do qualify. So I wonder if that's going to have the effect of, reducing the caseload, so to speak, from grandparents being able to bring, or not just grandparents, but other people who
Yeah,
are non-parents.
I think it could. I think that's the essence behind it, or I think the desire was to kind of stop a bunch of suits that probably should not have been filed. But with that being said, I do think that it'll prevent a lot. But I also encourage people to make sure that when they are seeking this type of relief, they are actually going to their attorney and having legitimate information.
Yeah.
What happens a lot is I'll have people who come in and their grandparents, and they'll tell me something that happened to Johnny or Susie 5 years ago. And I have to say, yes, ma'am, but as we sit here today, what are your facts?
Yeah.
Right? And so there are certain people who, sure, when I file what I file, we've got to go through the standing requirements as well. Now, keep in mind, there are several situations where if you are, for example, seeking a temporary order, or if you are seeking an SMC appointment, there are several suits where you'll have to file an affidavit anyway. But within that affidavit, you're going to now have to add the language about how do you have standing, right? And so that's very important, because you can get shooed out the minute the judge reads your affidavit.
Yeah. And I'm going to be curious to see how strict judges are going to be on this. If they're
Right.
going to read these affidavits and be like, nope, you're out of here,
Yep.
or
I cannot see a space where it's going to just be blanket carte blanche, you're out of here, just because we are dealing with a best interest determination.
Yeah.
And these are children who are a vulnerable part of society. But at the same time, I think it'll depend on the court, depend on the judge's kind of interpretation of everything that's going on, depending on the party's ability to appeal. And it's also going to depend on the size of the county.
Well, we shall see. So
Yeah.
thank you so much for that. So what's next? What is another area of law that is being updated coming up?
Well, let's talk about possession and access, because I don't know about you, but I have had several times where I have people come into my office and they tell me that the other parent is denying them access to the child.
Yeah.
How often does that happen for you, Mac?
Absolutely a lot. And typically when we talk about enforcements, okay,
Mhm.
we might be talking about child support enforcement, what you see all the time. But sometimes it's enforcement of possession and access, because the other parent will not let you see your kid, or
Mhm.
surrender them to you like they're supposed to.
Mhm.
So what's changing in this area?
Well, so one of the things I just want to talk about historically, and Mac, you jump in here. I have people who will come in and tell me that Sally or Tom is not letting me see the child. I have to make sure that the person that is telling me that is actually following the
Correct.
terms of the order, meaning you are showing up at 6 o'clock where you're supposed to be, or you're showing up at school where you're supposed to be. And I have evidence that that child is not there. I have evidence that you were there on time. I have evidence of all of those things. They will come to me and they'll tell me this is what's going on. I will give them the ability to file an enforcement. And what an enforcement does in a possession and access situation is it can set up where the person, for failure to surrender that child or return that child on time, can they'll have to end up paying attorney's fees. They'll have to end up giving makeup time and potentially jail time. That's what makes an enforcement unique. Well, I often have to tell people, hey, look, you are absolutely right on this situation, but odds are the judge isn't going to throw this person in jail. It is very, very difficult to get jail time on possession and access. Or at least that's what I found historically.
Yeah, I agree.
You'll see a lot of situations where I have to tell my client, slap on the wrist. That's what's going to happen. And you need to just get your makeup time, get your attorney's fees, and call it a day. And a lot of times my parties can't quite understand that, because they're sitting there going, well, I've got 10 times where she didn't release a child. And I have to say, I understand that, but I'm telling you, this is what's likely going to happen.
Mm-hmm.
Well,
yeah, now we have the changes. Huh?
I no longer have to say that, which, and I am saying this with glee. I never get glee when people go to jail. Well, depending on who the person is, but I never get glee when people go to jail. That's not what it's about. The overarching thing is I'm not sitting here going jail time for everybody. But one of the things about an enforcement is about deterrence, right? And if there's no real consequence, or every time we go to court, you know you're going to get a slap on the wrist, what's the point, right? So That has changed. Um, Now, what we are seeing is that the legislature is really, really taking these groups serious that talk about withholding the child and the impact that it has on a person's relationship with a child. You would agree with me that spending time with a child is your bonding. That's what it is. And when you cannot do that, it directly impacts your relationship with that child, whether it's negatively, all of those things. Well, the legislature has updated the enforcement language, particularly for possession and access, to read that if you let me make sure that I'm reading it correctly because I want everyone to be aware. Under 157.165, in an enforcement action, you are allowed to be placed on what's called suspended commitment, which is just essentially probation, meaning you need to follow the court's order or, we can put you in jail. Well, now what they're saying is if you are brought to court on another contempt and the court wants to consider community supervision or suspension of commitment, which would be that probation, the court no longer has the ability to do that. If the party that the respondent is in contempt of court for the failure or refusal to obey an order for possession and access to a child and has previously been found in contempt of court at least 3 times for the failure or refusal to obey an order for possession and access of the child. Meaning, for my baseball fans, 3 strikes, you're out.
Yeah.
You're going to jail. And it's not going to be something that's discretionary for the court. So if you are in violation and it's clear that there has been a violation of the order and you would be found in contempt again, you're going to jail. It's no longer a slap on the wrist. So the question then becomes, is it 3 separate orders holding you in contempt or is it 3 violations?
I would think the first. That was my first gut.
So that's the question, really. I'm with you. I think it's the first. But what's interesting is, and I want you to think about this. If I know you have 9 violations and I just break them up into 3 separate enforcements, well, if I know that you've got 12, let's do math. I went to law school, not math school. If I know you've got 12 violations, what stops me from putting 3 violations in 3 separate enforcements? Because on that 4th one, I know you're going to jail. That I find interesting.
Yeah, that could be interesting. I think the takeaway from me in all of this is that the legislature is getting serious when it comes to putting teeth into enforcement of possession and access. I think there's already a lot of teeth on the child support enforcement side. There's a lot of people who go to jail for not paying child support. But when you get into the whole enforcement of possession and access, i.e. visitation, sometimes I heard a lot of guys say this, like nothing, there's no consequences for her. Okay. And I say her because a lot of times, the mom might have custody and then she has to surrender the child at a certain time and place. And sometimes the guy doesn't help himself because he doesn't actually exercise. He doesn't do what he's supposed to do to see the child.
Right.
But let's assume that, he's doing what he's supposed to do. The court order is on its face being followed. He brings the officers. He does everything. However, he keeps taking the other parent back to court over and over and over again, and the judge just never wants to commit the person to a jail cell.
Right.
That is a big deal, because that's effectively changed now.
Yep. But wait, there's more. The other thing is, what has changed is that a finding of contempt for possession and access is now considered a material and substantial change. For purposes of a modification. And that you will find under 156.107. If they've been held in contempt, I'm paraphrasing here, guys, but if they've been held in contempt 3 times for failure to comply, that can be sufficient to modify an existing order.
So you can get custody, basically, if the other parent has a history of withholding the child from you.
Right.
Now, I think that was probably always the case, right? Most of the time, if you're alienating a child from a parent, that's probably grounds to go ahead and, under a modification, get custody. But now they're actually itemizing it and putting it down into the statute.
Oh, yeah. It's codified and it says 3 times. Okay. And what I will say is I'm with Mac on this. I always tell my clients, the ones that, and this is why I'm kind of happy with this new law. I would always tell my clients, and I ladies. I am team lady. I am a feminist, a womanist. I'm all of those things. But I find that with a lot of my male clients, what I will tell them is, because of the way the law used to be, don't do the enforcement, right? Or do the enforcement, but really what we need to be focused on is the modification. Because to me, that's a lot easier. It's a lot smarter, and it wasn't a waste of money. I mean, sure, you're going to get your attorney's fees awarded to you. There's no guarantee that they'll actually be paid. That's number one. But number two, it's just a lot easier for me to set up a mod than it is for me to go into court and ask that this person be placed in jail, knowing that there's probably not going to be a consequence to it. So what this has done is not only set up a consequence, but set up further litigation. So guys, if you are withholding a child and you are doing it for an emergency purpose, you need to be in court making sure that you are not just violating your order. Now, if you are withholding the child because you just don't like what Bob did, not sufficient. It's not. And I think people need to be more familiar with what defenses are to possession and access violations, because it's not just, oh, I didn't, Bob is abusing the child. Okay, great. But you also need to seek further litigation. There needs to be more, because that's generally what the response is. The other thing that I always make sure that everyone understands, and this is just a side note, possession and access and child support are not equal. So this is where I got to jump on the guys. Just because you're telling me that Dannielle is withholding your child, Mac, you don't get to turn around and go, well, I'm not going to give her any child support, because you're in violation, I'm in violation, and we can just share a cell. Right? So
Thank you for saying that. Just because he's not paying child support doesn't mean you get to withhold. And just because she's not living for your kid doesn't mean you get to not pay child support. They're two independent causes of action, and you go to court, get a lawyer, and take care of it.
Right. The other thing that I found interesting this last legislative session, in addition to other things, is that when it comes down to CPS, and this is kind of a niche area that a lot of people aren't super duper familiar with, but it does impact people on a daily basis, is they've gotten rid of what's called the O grounds for termination, meaning the ability to terminate parental rights based on failure to comply with the court order or particularly your family service plan. I have opinions on that, but generally in a CPS case, when you are in CPS litigation where CPS has taken conservatorship or temporary managing conservatorship or custody of your children, you get what's called a family service plan, and that should be narrowly tailored to why the child came into care. Like, for example, if it's drug use, that service plan should be really, really dealing with the issue of drug use and trying to get you in a space where you are no longer, where drugs are no longer negatively impacting your life or the life of your children. It used to be, the grounds used to include a ground under O where you could terminate for failure to comply with that service plan, which became an order of the court, and other orders. Like, for example, if you were ordered to do, if you appeared in court and the court said, hey, I want you to go take a hair follicle, and you failed to do that, that was also a court order that could go under that ground. Now, and keep in mind, termination also includes a best interest prong. So we're going to put that to the side. We're just talking about the termination ground. Now you no longer have the ability to terminate based on failure to comply with the court order or failure to comply with your service plan.
Yeah. So you do a lot of CPS work, and this is the queen of CPS litigation right here. I'm telling you the truth. And so you know what you're talking about. Basically, this seems to me as a way to, I guess, not make it as easy, to terminate, before. Now, I'm wondering to myself, why? What's the rationale for it? I don't know. Do you have any thoughts on that?
I think what was happening, particularly with CPS, and here in Texas, they're called the Texas Department of Family and Protective Services, otherwise TDFPS, but we're saying CPS because everyone knows Child Protective Services.
Yeah.
What was happening was, in my opinion, the goalpost was moving. Or you had a service plan that, while they are supposed to be narrowly tailored to why the kids came into care, they contain things that people didn't need. Okay. Or they contain things that, while you may need it, it's something that you could never really complete. Like, for example, you have individual therapy, right? people can be in therapy for the rest of their lives and be perfectly fine. And in fact, there's factors out there that probably say that you do need therapy, right? Because life is just hard. But the whole concept of that being based on an individual who likely is contracted by CPS saying that, Mac, you're healed, you're cured. If a lot of times that can just be, hey, Mac, I don't like your tie, and so maybe you're not going to get a satisfactory discharge from me. Or it could be, hey, Mac, I just really liked your tie. You were telling me a whole bunch of nonsense in there, but I'm going to give you a satisfactory discharge anyway because they only pay me up to 8 sessions. So boom, you're satisfactorily discharged, even though you're not even addressing your issues. And so I think the whole idea was to not let service providers get too out of hand, but also not let CPS set you up in this never ending story. In addition to that, what I think people have to understand is before under O was a weak ground already. And most county attorneys, that would be the people that represent DFPS, they're usually county attorneys, and some smaller counties are district attorneys because they're within that same office. Most of them no, don't terminate only on O. Go find another ground because O is such a weak ground that can be appealed. Because there were so many things within the code that allowed for, like, for example, if you didn't complete your service plan, but you were able to put up a good defense as to why you didn't, then it's weak and you're likely not going to get terminated based on that. And a termination based on an O ground, does that really speak to best interest, right? Because you still have to have that best interest prong. Termination is, it is, this is the tackiest thing, but it's accurate. It's the death penalty of our stuff over in the family building.
Yeah, I was just going to add, you know, that this is not a light thing. This is a big deal.
It's huge.
Terminating a parent's rights is basically severing forever their relationship with their child. And so I was thinking perhaps the legislature was just like, look, we want to make sure that if you're going to pull this death penalty level of, you know, a consequence because something's happened between that parent and the child, you want to protect the child. You want to make sure that you only do it based on the actual merits of what that parent might have done or neglected or whatever, not based on any kind of technicality.
Right.
You know, and so it's a takeaway that I have, but you're the one who does this kind of work a whole lot. And I'd be curious to kind of hear, you know, what you end up seeing in the future.
Yes, that's going to be very interesting because it opens kind of Pandora's box, in that I do think that we have to make sure that when we are severing these rights, which, by the way, it is forever, but there's also a statute that came up, I think, either the last legislative session or the session before, that allows people to renew their parental rights, but there's all kinds of nuances to that. But you're right. It's making sure that when we are bringing these cases, especially since it involves the state.
Yep.
Now, DFPS is about to get privatized, but that's a whole other issue. But when you're involving the state in your life, you want to make sure that they are up there. This isn't individual citizens.
Yeah.
So
they get the power. So you got to make sure.
And the resources and all of that. Yeah.
Yes. So get a good lawyer on your side. And okay, so what's next? What's the next area that's being updated that stood out to you?
Well, there are quite a few areas. I mean, obviously there was an update to attorney's fees, which I won't bog y'all down with, but was it interesting to me as the attorney? Absolutely.
Yeah.
I think that one of the major things that you're going to see also is with protective orders. We're seeing a change that is requiring protective orders. And don't quote me on this, but requiring protective orders when there is a case already pending in another court to be attracted back to that court so it can be heard by the same judge. One of the major issues that I don't know if you've seen, well, I can attest to this, having practiced in Harris County. There was a point, not now, but there was a point where people were running to protective order court to get protective orders because they knew that it would negatively impact what was going on in their family law case. Because once you have a finding of family violence, you're very limited in what the court can do on a final order. And so you would have one fact finder hearing certain things, and that person may or may not rule one way. And then you would have it back over to the other court who actually heard way more facts than what the protective order court heard, and would be hamstrung by what the protective order court ruled. And so I think the whole premise behind that is, let's stop forum shopping and let's really make sure that it's the same fact finder who has everything and not just one fact finder who has a very narrow scope of what's going on, especially since, and you'd agree with me on this, protective order court, the notice required for protective order court is very, very little.
Mhm.
You know, I mean, you can serve somebody with a protective order, have them in court, next day, 2 days later? And whereas in family court, and I'm not saying that the notice requirement has changed, but in family court, especially if there's litigation pending, that judge at least has some idea of notes, right? Because over in regular district family court, you can make allegations of family violence there. Findings of family violence can be made over there. And sometimes, and I'm not suggesting that this always happens, but sometimes you'll have a district court who declines to make a finding of family violence based on the evidence that they've heard. And then you can have a litigant go over and go, well, I'm going to go to Mac's court since Dannielle didn't agree with me. And Mac may go, hey, I think this is family violence. And now Mac has made a finding of family violence that can impact a party for 2 years or even longer. And then send that litigant back over here where a family violence finding has already been made, and I can't do anything with that. So
Yeah, it can get very technical, especially between the forum shopping. Literally in Harris County in Houston, it's one court is in the 280th and the other court's across the street. And people go back and forth sometimes. And so I wonder if that was one of the reasons. Being the biggest city in the state, I think what we end up doing here influences the legislature a whole lot.
yes.
Okay, so do you want to start wrapping it up? Anything else that you want to close out with that people need to know before this year's out?
Get to know your legislature. Get to know who's speaking for you, because that's what they're doing, right? They're speaking for you. They are speaking for the Texas, essentially, right? They're speaking for Harris County. They're speaking for Fort Bend. They're speaking for Austin. They're speaking for wherever. They're speaking for College Station. Whoop! They're doing all of those things. And the reason that it's important that you are active, but you're also aware of what's going on, is because what they do there directly impacts you, even if you don't think it does. I came from a house where my parents married, you know what I mean? And so but for the fact that I am a family law attorney, it was very low probability that I was going to see the inside of a family law courtroom. That doesn't mean that what was happening wasn't going to impact. Like I said, I have family members who my parents helped raise, and that could have easily brought us into family court. So family court, legislation, all those things, they touch your lives every day. So make sure you're aware of what's going on. Make sure you're voting. Educate yourself.
Awesome. Well, Dannielle Simms, thank you so much for coming today to talk about these updates in the law. And so I'll share your website. If people want to get in touch with you, what's the best way they can do that?
Give me a call, 713-532-0100. Or, ask Jeeves. Not really. That's not real anymore, guys. That's debunked.
Yes. And simslawgroup.com is your website.
Yes.
And of course, that's the best place people can start off to learn about you and your firm. Okay. All right. Well, thanks so much. Until next time, everyone, Lawyers Mediators International, check this video out and all the other ones on the YouTube channel and LMIpodcast.com. All right. Signing out. Take care, everybody.
Bye, guys.